We are currently working with a group of data wranglers from across Southern Africa to collect information about seizures, arrests, court cases, and convictions related to wildlife trafficking. One of the biggest challenges with this has been getting good access to data, which is also official. This is why we asked environmental attorneys Lauren Nell and Zahid Leha from the Legal Resources Center to join us today. Lucien completed his LLB at Wits University in 2010 and was admitted as an attorney 3 years later. He has previously worked in the construction industry and most recently as a researcher at Wits University. He's also a member of both the IUCN World Commission on Environmental Law and the Environmental Law Association of South Africa. Lauren has a BA Law degree, a master's degree in international law, and a postgraduate diploma in labor law. She hopes that through education and information, environmental law can be highlighted in all aspects of the law with an awareness created that our wealth lies in the environment that is protected and enjoyed and not in short-term commercial gain. Zahid Leah completed a BA in English and Politics and LLB at the University of the Witwatersrand in 2017. He has previously worked at the Wits Law Clinic, Lawyers for Human Rights, and in the dispute resolution and public law departments at a large law firm. He is currently completing his articles at the LRC and has a passion for administrative, constitutional, and human rights law.
Thank you, Andiswa, and good morning to everybody. It's great to have such a wide array of people joining us today. I'm sure you can see that the PowerPoint presentation has been flighted. Not everything is going to be covered in the PowerPoint presentation, but of course we'll share it with everybody after this session. So welcome everybody, and it's great, yeah, like I said, it's great to have everybody here to hear about access to information. Just as a quick introductory for us to get to know each other and to explain what's going to be covered today. You know, the one thing we realize, you know, in South Africa, that journalism is what maintains democracy. It forces and holds people to account. And it obviously allows information to be disseminated to people so that they can make their own informed decisions. And access to information is absolutely critical when it comes to dealing with that. If you don't have access to information, it becomes incredibly difficult to inform the public and to be a successful journalist. So access to information has grown in the past couple of decades into a vast array of law internationally, regionally, and in Southern Africa. There's a mass movement currently happening in the world where you have civil societies fighting governments to make sure that access to information is a right that continues to be enforceable and protected and respected in the various countries. What's really interesting is that currently almost every country in the world is either part of a treaty or has national laws that regulate access to information. Taking that into consideration, what does wildlife crime and access to information have to do with each other? Well, UNEP and other institutions advise our biodiversity crisis is one of the biggest challenges humanity will face in its lifetime. It's become such a crisis that even the International Criminal Court is now looking at making ecocide the fifth recognizable international crime against humanity. In order to understand and report on this crisis, access to information plays a critical role, particularly with trying to get information around courts, trying to get information around statistics with government and what programs they're trying to deal with. Wildlife crimes, as we know right now, doesn't get the exposure that it deserves. You know, there's not as many stories as we would appreciate to actually be publicized and written by journalists and think tank organizations. So this training session, hopefully, to make it easier for people who want to investigate wildlife crimes in Southern Africa to understand the legal issues when we're dealing with access to information. Okay, so just a couple of important legal concepts which I think are important for us to understand when we're moving forward, because we do tend to say these words quite often. So defining a wildlife crime. So wildlife crimes are typically referred to green crimes. So what do we mean by green crimes? It's crimes that are linked to biodiversity. So, the poaching of a rhino, the transporting of illegal coral reefs that were taken, the furniture business in terms of rosewoods, for example. So that's quite important for us to understand from that perspective. What do we mean by wildlife crimes? So there's two type of crimes that are linked to wildlife crimes. There's the direct conduct or act, and then of course there's the secondary act, and that's quite important. So let's just take example, the poaching of a rhino. So the poaching of a rhino would be the direct conduct, the green crime that happened where the rhino was killed and the horn was chopped. And then there's all the secondary crimes that also follow suit, which aren't typically a wildlife crime, but have just as much impact and should be defined a wildlife crime when it includes a conduct of killing a rhino. And that would be, for example, an unlawful license of a firearm, the unlawful use of various drugs to dart a rhino, the transportation of the rhino horn, unlawfully transporting it overseas, fraudulent documentation to say, well, it's not a rhino horn, it's an ornament or something like that. So you've got two types of crimes. It's quite important that we understand that when we're trying to deal with access to information, because if you're going to court, there might only be a crime of fraud when there was an unlawful documented piece of paper that fraudulently allowed the rhino horn to be transported overseas. So we need to be aware of that. Defining access to information. So access to information is the process of getting information that you may find useful for the purpose that you're seeking. So if you're a journalist and you want to find out how many rhino horns have been transported overseas, you would then have to approach the department to see how many rhino horns have been seized, for example. Defining a legal system. So a legal system is referred to a set of laws that a country operates under and that binds the state and persons within that state. UNEP, I think we all know who UNEP is, United Nations Environmental Programs. And then CITES, which is quite an important one, is the Convention on International Trade and Endangered Species of Wild Fauna and Flora. And this is quite an important international agreement that we'll get into a little bit later, that everybody needs to be aware about, because there are various legislations at a national and regional level, and then this international level that have an impact on what we define as wildlife crimes internationally. So from now, I'll let Lauren take over for the next two sessions, and then I'll be back for the third session. Thanks, Lauren.
Thank you so much, Lucian. So the first part or portion that I'm going to go through is obviously the legal frameworks in Southern Africa, but also more generally. In terms of the legal framework, we have three types of law. We have international law, which is the bodies of rules established by custom or treaty and are recognized by nations as binding their relations with one another. In other words, these laws are only binding due to the fact that states agree for them to be binding on each other. Then on a lower level, we have regional law, and that can be defined in two sort of spectrums. The first is that it designates any sets of rules with which a region gives itself because of the distinctive value shared by the members in that sort of collective or that region. And in the second sense, it's any rule having a regional scope of application. So just to, obviously look at the difference, you have the ECHR, which is the European Court for Human Rights. So that would be sort of the second sense of regional laws, where rules obviously have a regional scope of application across Europe. And matters are tried in that court, and those matters then are considered to be binding, those cases. The first sort of sense where you have a set of rules that bind states together because of distinctive values would be something like the European Union, or in the case of Africa, the African Union. And then obviously on the third level, we have national laws. So that's the laws of the country that you're in. And those laws then are binding. In terms of international law, especially in the case of access to information, you have the Universal Declaration of Human Rights, and specifically Article 19. And that states that everyone has the right to freedom of opinion and expression. And this right includes the freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. So all countries that are member states to the United Nations have accepted this. As I defined international law, it is laws that are accepted by states because they agree to be bound by them. The right to access to information is also highlighted in the International Covenant on Civil and Political Rights in Article 19. which states that this rights include the freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through any other medium of choice. Just to give you an idea of the scope of acceptance of the International Covenants on Civil and Political Rights, here is a map. The dark blue is states that have accepted to be bound by it. The light blue is states that have only signed the actual international covenant. And then the orange is states that have taken no action in regards to this covenant. But as you can see from the dark blue, across Africa, across the world, this is very much accepted by states who are parties to the UN. More on a regional law level, especially in Africa, we have the African Charter on Human and People's Rights, which comes from the African Union. And in Article 9, it states that every individual shall have the right to receive information. Further, this is reiterated by Article 9 of the African Union Convention on Preventing and Combating Corruption, which advises that legislative and other measures must be given effect to have the right to access to any information that is required to assist in the fight against corruption and related offenses. More so in regards to this, the African Union has gone far further in terms of the fact that a declaration on the principles of freedom of expression in Africa has also been obviously implemented by the African Commission. And what this declaration seeks to do is to elaborate on the scope and content of some of the rights that are obviously contained in the African Charter. In this case, this would be Article 9, which is the right to access to information. But this declaration is considered to be a part of soft law in international law, which means it is not binding. It is only but a recommendation in regards to this, and also an expansion on the rights, or the Article 9 for the right to access to information. In terms of the declaration, there's been two versions of this that have been adopted. There was one in 2002, and there was also one in 2019. In 2002, when it was adopted, it highlighted that obviously states should have the right, individuals should have the right of access to information held by public bodies and companies. And then that freedom to information includes that everyone has the right to access to information held by public bodies. Everyone has the right to access to information held by private bodies, which is necessary for the exercise or protection of any rights. What's interesting is that in 2019, it started including rights that obviously extend to the internet. And what it stated is that there was a key role that the media played, and that there needed to be a promotion of free flow of information. And that state parties to the African Charter should create an enabling environment for the exercise of freedom of expression and access to information. That access to information should be protected not only offline, but also online from any interference from states. And that there is specific protections afforded to journalists in Principle 19 and other media practitioners. Moving more forward, that the safety of journalists and other media practitioners should be protected in terms of Principle 20. What's interesting is Principle 9, which is justifiable limitations. So justifiable limitations are limitations on the rights of access to information. So that looked at the fact that if it was prescribed by law that you could limit access to information, or if there was a legitimate aim, or if it was necessary and proportionate. And limitations examples include where it affects someone's rights or reputation, or it was in the interest of protecting national security, public order, or public health. Further, more specifically to journalists in Principle 25, there was a protection of sources and other journalistic material, which obviously includes the right not to have to reveal confidential sources. In Principle 28, it mentions the fact, in light of the previous principle where the right of access to information can be limited, that there must be maximum disclosure unless there is a narrowly defined exception that exists. So on the one point, it's saying that obviously the right can be limited, but it's saying those limitations must be extremely limited. What's interesting about the declaration, it also gives a process for accessing information. So on a practical level, that the request for information can be orally and in writing and must be in conformity with processing requirements. Further, it speaks about the implementation principles, and it states that obviously states shall adopt legislative, administrative, judicial, and other means to include this in their law, and they should be guided by the African Commission's Model Law on Access to Information for Africa, or the African Commission's Guidelines on Access to Information and Elections in South Africa, and that states should periodically report on the right to access to information in terms of this declaration. The model law is a more sort of practical document which outlines how access to information will look, not so much the rights afforded in terms of access to information. And it's created as a tool for lawmakers in African states. I just highlighted obviously the sections in the model law that were of particular importance. And that is like, obviously in section 6, the duty to create, keep, organize, and maintain information. Section 7 highlights proactive disclosures. In other words, the state should proactively be giving access to information. And examples are given of manuals, policies, or procedures. And it's outlined that this should be done within 30 days of those documents being created. That a designation of an information officer must take place, and that obviously there should be rights of access. But more importantly, the request for access and what that should include. So a request must provide such detail concerning the information requested as it is reasonably necessary to enable the information officer to identify the information. This point is incredibly important, and that a lot of times when access to information is requested, the requests are extremely vague. So therefore, it has to be quite specific, the information you're looking for, and also the person that you're looking for that information from should be specific. In other words, in the background, you must understand where that information comes from and who holds that information and what type of information is being sought for. In terms of section 15, it outlines obviously that the response to the request should be answered within 21 days, and that you are entitled to a right of internal review should that request be refused. And further, that if the internal review is unsuccessful, that you have the right to apply to a courtroom for a review to allow you access to that information. In terms of obviously the African unions across Africa, we also have the Southern African Development Community, and they have also stated rights around access to information, with the Protocol Against Corruption requiring state parties to undertake to adopt measures to create, maintain, and strengthen mechanisms to promote access to information and to facilitate eradication and elimination of opportunities for corruption. So this is just a rating map from the Center for Law and Democracy. And what you can see is where it's most red is where access to information is obviously rated highest. And obviously moving to green is where it is rated the lowest. So it just gives you an idea across Africa specifically where it is in white, that they are not rating any access to information taking place. And that's exactly what's stated, is that few African countries have actually passed freedom of information or access to information laws, while a lot of African countries are in the process of implementing legislation to allow that to happen. As I said, there's 3 levels. There's international law, which is like the United Nations. There's regional law, which we've looked at, of the African Union and SADC. And then there's obviously national law. And this is just to give you an example of how that works. So in Botswana, the constitution does provide for free speech and free press. But at present, there is only a bill out for access to information, which is the Freedom of Information Bill, which has not become national law in Botswana. In Malawi, there is a constitution that states in section 37 guaranteeing the right to information, and there is also an act which has cemented the right to access to information in the Access to Information Act, which states a request for information may be made orally or in writing and shall be addressed to an information officer. In Mozambique, the situation is a little bit more complex, and this sort of highlights this issue that's raised by the declaration, where it states that obviously certain laws in a country can limit your right to access to information. So even though there is a constitutional right to freedom of expression, freedom of press, and right to information in the Freedom of Information Act of 2014, with regulations being passed in 2015. There were laws brought out in 2018 which limited the right to access to information for specifically journalists. However, that law has been revoked in May of 2020 for being unconstitutional. But now again, there is presently in the COVID-19 emergency decrees laws that are limiting the right to access to information. In Namibia, there is no legal freedom of information framework at present. And the Namibian constitution, though, does guarantee the freedom of expression, and it's implied that that includes the right to information. But there, in addition to that, are certain restrictions to that information, like national security and public order. And they also at present have a bill that is in Parliament that has been tabled in 2020, but has not become law. In the African context, South Africa has the strongest legislation in regards to access to information, with our constitution providing that everyone has a right to access to information held by the state, and it provides for the horizontal application of the right to access to information held by another person to everyone when that information is required for the exercise of protection of any rights. This includes private bodies in South African legislation of the promotion of access to information. So Section 11 allows you to obviously request records from public bodies, and Section 50 allows you to request records from private bodies. And Section 18 and Section 53 actually give you the form of request. So an example, here is the request for a public body. There is an actual form that you fill out that you can find on the internet that you will submit to an information officer of a public body. And Form C is an example of a private body request that can be made. The last country I'll look at is Zimbabwe, which obviously in their constitution states every person has the right to freedom of expression, which includes the right to freedom to seek, receive, and communicate ideas and other information. Part B is court data, and this is more sort of the practical aspect of finding information. How do we find information, and where do we find that information? So specifically information from courtrooms is quite substantive in that it wouldn't be stats, it wouldn't be numbers as per se, but it would be the actual court cases that are being heard by those forums. And that's normally inclusive in a court file. So court files can look different in the sense that you have civil matters that are being heard. Like Lucien obviously mentioned, you could find information from a matter that is maybe about damages, but it relates to sort of a wildlife aspect of a crime that has taken place. And then obviously you have the criminal court side, which has different information in. So with a civil matter, you'll have things called pleadings and notices. So like documentation that is sort of exchanged between two parties, to individual parties, private persons in a matter. And then you'll have your criminal court files, which will include things like charge sheets, dockets, and obviously the judgments that are coming out at the end of the day. These normally are only available once the matter has been fully heard and can only be reported on once a decision has been made. Because in most countries around the world, you're obviously innocent until proven guilty. And therefore, until guilty charge is given, an accused is entitled to the right to have their matter heard and to be tried fairly. With judgments and court orders, that can also be found in the court file, whether it's a civil or criminal matter. What's more interesting is other information sources can be like transcripts of matters heard. So in most courtrooms, the matters are being recorded by a transcriber. Those transcriptions or those recordings are kept by the courtroom and can be accessed by someone of the public. Because in the same note, if a hearing is being heard in a courtroom, you can obviously go sit into that courtroom and listen to that hearing. The only exceptions to that rule is like where a minor is involved, they may obviously make it a closed hearing in the sense that the public is not allowed to hear that information. Or if there's like state secrets being heard in that meeting or very confidential information that's protected by the national law of that country, that hearing then can be closed as well. But the general practice is that all hearings are open and therefore the recordings of those hearings are also open. I was actually giving an example of this to someone one day. I went to a courtroom with a flash disk, because most courtrooms obviously are digitally recording. And I asked for a hearing that had taken place on a specific day. And they just allowed me to put my flash disk in, get my recording, and leave. So yeah, so that's an interesting source of information. With public data from the courtrooms, you obviously have layers of courts. So your first layer is your lowest courts. So in South Africa, that's called a magistrate's courts. In other jurisdictions, it goes by other names. And those courtroom hearings are generally not very accessible in the sense of like the internet, or that the case numbers or the rolls are actually, so the rolls are obviously the hearings that are taking place that day are publicized on the internet or on virtual platforms. The lower courts are generally much more less sophisticated in that they aren't on digital platforms on any level, and also that their judgments aren't freely available on digital platforms. So that differentiates from your high courts, which generally are on digital platforms, and there are reported court cases generally coming out of there. So a reported court case is one that obviously a judge feels needs to be out in the public. In South Africa, there's been an interesting trend where SAFLI, which is sort of a database that's freely accessible, was only generally giving the reported cases that were happening in courts. And we see a trend now happening where they are publicizing more of the cases, even though they aren't reported. So there's also Worldly, which gives access to, like I said, all countries' databases. And that's the information that the country is allowing to be accessible. So you can find high court cases there. And then in most jurisdictions, there's the highest court. So in South Africa, that would be our constitutional court. And all those court cases are actually available on the internet through the Constitutional Court's website. But also more so in the sort of digital era that we've moved into, we're seeing court cases playing live on things like YouTube. So anyone can actually view that court case. So like I said, the records of court are public and they can be requested. Just on a practical level, you can request, obviously court files from lower courts or higher courts, and the people working there in South Africa are called registrars or clerks, and they may come by different names. It's obviously the staff of the actual courtrooms, but you need to be quite persistent with court officials sometimes. In that I found in the South African court system, I sometimes have difficulty. So you need to understand what you're looking for, understand the system, understand exactly the document or the case that you are specifically trying to find or trying to access information from, so that you can almost be persistent with the court officials to get that information. So just for interest's sake, what Worldly looks like, it's the World Legal Information Institute. And you'll see on the left-hand side, it states all countries, all databases. You'll see there's at the top, there's the Philippines National Privacy Commission Advisory Opinions 2016. So it has quite a wide range of information. It may not have the exact information you're looking for, but it has quite a wide range of information. Then more specifically, obviously what we're focusing on today in terms of court data is oxpeckers and sort of the stats that are being looked for, which is seizures, arrests, court cases, and convictions. So more specifically in regards to that aspect, that obviously stems from the criminal courts with your seizures, your arrests, your court cases, and convictions. So in terms of seizures, they're generally taking place by the police. In terms of arrests, that's also generally taking place by or done by police services. Interesting enough, for criminal court cases, the state will always be a party to that case in most jurisdictions. So in South Africa, the abbreviation S is used. So it's S versus whoever obviously is the accused. In other countries, the abbreviation could be different. But in, like I said, most jurisdictions, the state will be a party to those cases. And that's how you can identify that this is a criminal court case versus a civil court case. In terms of convictions, that would be your court order judgment, which will obviously be in the court file after the matter is heard. More specifically, on a practical level, you also need to understand, and that's why I went through the layers of laws from international, regional, and national, is to understand your specific country's national law. Because certain convictions in different jurisdictions are heard in certain courts. So, like in a magistrate's court level, it's the less serious crimes that would be heard there. Well, in a high court, your more serious crimes would be heard. And each jurisdiction has their own sort of way of leveraging on that. So to be able to find the specific information you're looking for, let's say if it was rhino poaching, you would have to go look at the act that regulates that offense, then look at the criminal law that obviously could find a person guilty of that offense, and then figure out which court it would be in. So let's say a magistrate court level, high court level, and that's then where you would find those types of cases. Specifically with courtrooms as well, one of the main problems that we have in South Africa of accessing court information is that you need a case number to do it. So that's very difficult if you're looking for information. Like in South Africa, you couldn't go to a court official and say, I would like cases on a certain type of plant that's being, there's an offense for, and that has been sold illegally. A court official in South Africa would not provide a lot of assistance because that's not how they are sort of filing their court cases. They file their court cases in South Africa specifically for reference numbers. So it's also important to understand how your courtrooms are actually storing this information and what is the reference points that they use for that information of the court files. More so for stats, obviously, like I'm saying, courtrooms are quite difficult to get that information from, but your departments of justice, your Department of Environment, or your police services would be able to give you those sort of figures if you requested that information from them, instead of going to a courtroom and obviously trying to figure out how many court cases were heard in a specific area. So just to give a sort of a wider scope example of this, looking at African countries, these are the different court systems that run across these 6 countries. So like in Botswana, their highest court is the Court of Appeal. Malawi, it's the Supreme Court. Mozambique, it's the Supreme Court. Namibia has also a Supreme Court. South Africa has a constitutional court, and Zimbabwe's highest court is their constitutional court. You also notice that like Mozambique has 4 layers of courts. So they have district courts at the lowest level, provincial courts at the next level, courts of appeals on the next level, and then the Supreme Court. So there's 4 different courts that you need to take in cognizance. One, Botswana, they have the Court of Appeal, the High Court, and the Magistrates Courts. Interesting enough, even in South Africa, we have at the top the Constitutional Court. Below that, we have the Supreme Court of Appeal. Below that, we have a High Court, and then we have Magistrates Courts. But Magistrates Courts are divided into district and regional, and especially in aspects of criminal law, district courts take the lowest offenses, while regional courts take the next level of highest offenses, and then your high courts try certain criminal offenses at their highest levels. So moving on regard that is, so where, I couldn't find it for a court, where else could I look in terms of other countries? So I looked across these countries as a spectrum, and like in Botswana, you would have the Environment, Wildlife, and Tourism sort of department that you could ask for stats or information from, because they would be recording this information that is coming through the courtrooms. Malawi, the Wildlife Detection Dog Unit could be assistful in environmental or wildlife crimes, because that's obviously why they've been implemented in that jurisdiction. Mozambique, law enforcement and the anti-poaching at Mozambique's National Administration of Conservation Areas department could be sought information from. Namibia, the Ministry of Environment, Forestry and Tourism could be looked at. South Africa, we have the Department of Forestry, Fisheries and Environment. And then in Zimbabwe, there's the Department of Environmental Management Agencies. So this slide is just to give an idea of, obviously looking further than just your court data as per se of what's coming out of the courtroom, because that court data is then obviously being looked at by certain departments who need that information, and they then would be keeping stats. So interesting enough, you'll see with Botswana, I've included things like the Financial Intelligence Agency. So the reason for seeking information from them is they obviously are looking at big amounts of money, and especially fraud cases or cases where regular amounts of money are flowing through. So therefore, they may be picking up on a trend with obviously wildlife, let's say like poaching of rhino horns, and rhino horns obviously having fluctuations in people's bank accounts irregularly. And so they could be a source of information as well. In terms of, like I said, national law, you need to understand your national laws to understand the crimes that obviously, or the offenses that are being committed, to understand which courts would be holding that information. So I just gave an example of the main laws in each of these countries. So in Botswana, there's the Wildlife Conservation National Parks Act. Malawi, there's Malawi's National Parks and Wildlife. Mozambique has quite a different system to most of the legal systems in Africa, and that you'll see it will say Law 16 of 2014, which is a conservation law. Also, a lot of their laws are obviously in Portuguese, so language barriers also need to be looked at when trying to seek information in certain jurisdictions. Namibia, Controlled Wildlife Products and Trade Act. South Africa, obviously, Lucien's mentioned CITES, so we've made regulations regarding that piece of law. And then we also have the National Environmental Management Biodiversity Act, which outlines the offenses in terms of wildlife crimes. Zimbabwe has the Parks and Wildlife Act. These are just interesting snippets I got on these countries. You know, like it states quite clearly when you do research that Botswana has no centralized database recording prosecutions and court cases relating to wildlife crime. So therefore, as a journalist on the ground or as a data wrangler trying to find that information, you're going to have to go to quite a few sources to then try and get those statistics. Like I said, from a courtroom to the Department of Environment, to the police services, to see obviously how many charges were laid or how many arrests have happened in terms of specific spectrum of information you're looking at. And that understanding or the background that you'll need is to understand where those crimes obviously are offenses, where those offenses are going to be heard, and also even with the police services to understand which sort of unit in the police would be arresting those types of people for those types of offenses. In Malawi, it also states something very, very similar to Botswana, in that there is a lack of reliable available data, making it impossible to identify detailed crime patterns or trends. And that was just in generalistic terms of criminal law in Malawi, not specifically wildlife crimes. Mozambique, it also states crime statistics are not readily available in that jurisdiction. So the last aspect of court data is to look further than that, is to cross-boundary aspects. So obviously with wildlife crime, it's not just a crime that happens within one country. There's obviously a lot of movement of goods, or obviously movement of these crimes taking place across borders of countries. So another information source is to go outside your jurisdictions and look at like information requested from Interpol, or to look at the United Nations and see what kind of information they're gathering. Also obviously the Worldwide Fund, and also then interesting enough to look at export trends. So I just obviously I did a bit of research and looked at the World Integrated Trade Solutions, which is monitoring trade that is happening between countries and the monetary amounts that are moving around. And obviously from that, you could maybe pick up a trend as well.
So this section is dealing with proof of fact and evidence. So when I mean by evidence, I don't mean evidence in the legal term, you know, that you need evidence to prove a crime had happened. This is evidence that's needed to prove a fact, okay? And the importance of that when we're dealing with access to information is that if you're unable to substantiate your fact, it becomes very difficult for investigative journalists to then actually give statements of fact to inform the public. You know, making analysis and making analogies and stuff is all great, but that obviously needs to be backed up by some sort of factual context, and that is done by evidence. So sorry about that. I must just get my button near mute in case I have to cough again. Apologies. So what is a fact? So for example, you can see I've got two pictures on the right hand side. It says I am tall and Malawi has a lake. Okay, so when we talk about that, I am tall, is that picture truthful or not? No, it's not truthful, because in fact, in that picture, the person in the red t-shirt is in fact short. Um, Malawi has a lake. Well, yes, Malawi does have a lake, but how do you know that's truthful? Well, you take a map out, you look at that map and you see, okay, well, Malawi does in fact have a lake called Lake Malawi, or you go to Google and you take an image. So that's the difference essentially between a fact and evidence. A fact is a statement that you're trying to say something about, and then you need your evidence that you prove, in fact, that fact is correct. Like, for example, Malawi is in fact a lake, and that is proved by a map or by a picture that was taken when you were there in Malawi. So when a statement of fact is made, proof of such statement of fact is required. In other words, you have to prove that crime X arose from person Y. So, like I said there, see the picture, I'm really short, does Malawi have a lake? So how can one prove a statement of fact? Well, you do that by collecting evidence. So the question is, what is evidence? So evidence is what proves a case. In terms of criminal cases, just out of interest, it's the information that was used by an investigating officer and handed over to the prosecutor. So typically when you talk about wildlife crimes, you have two parties. You've got your police or a specialized unit, and then you've got your prosecutors. And within the prosecuting authority or the person who's going to do the prosecuting is usually specialized units when we deal with environmental wildlife crime. Unfortunately, in South Africa, that doesn't exist from the prosecuting side, but from the investigative side, within DEF, for example, you've got three branches of people who actually investigate. So they're actually called the green scorpions, the brown scorpions, and the blue scorpions. And they've got various investigative powers. Their real names are environmental management inspectors, but we have coined them the green, blue, and brown scorpions. So in terms of investigative journalism, evidence, for example, could be a video of police destroying hard evidence of a crime that actually took place. So if you're going to, and quite often, in Africa and other jurisdictions, because the wildlife sector is such a profitable sector, if you're able to sell the goods at higher rates, and you're able to elicit that outflow of natural resources, it is a very profitable, unlawful sector. In fact, I don't know if anybody knows this, but it's the third largest criminal syndic sector in the world, besides human trafficking, and there's another one, I think it's drug trafficking. So it's a massive industry. We're talking about billions of rands of illicit money coming through and from. And so that often involves officials. There's been hundreds of examples of officials who've been involved in poaching, who've been involved in providing arms, who've been involved in forging signatures and forging documentations, unlawfully processing information so that the goods can be sold overseas or to people within their country. And so quite often, some of the investigation that comes around is looking at the information of maybe how many state officials have been prosecuted. That might be potentially an interesting topic. But in order to do that, you need to get your facts. And in order to get your facts, you need to get the evidence, and you need to look at access to information. And so evidence plays a very important role in gathering that access to information. So, here's some interesting examples from South Africa. So in South Africa, there's been 12,154 dockets that have been opened since 2010 up to 2017, for example. Cases that were handed over to the National Prosecuting, which is the NPA, only 2,900 cases were handed over. So immediately you're asking yourself, why is there close to 9,000 cases that nothing's really been dealt with? Arrests by EMIs. So EMIs are your environmental management inspectors. Well, there was about 11,000 arrests. So you can see here by this information that there's dockets that have been opened close to 12,000, 11,000 people have been arrested, but only roughly 3,000 cases went to court. And out of those 3,000 cases, only 586 convictions actually occurred in South Africa. Now, 586 is actually not a bad record. you're talking about almost two people per day being convicted of a crime in the environmental wildlife area. So it's quite interesting to look at from that perspective. But when you look at how many dockets and people were arrested, when you're looking at 12,000, well, you less than 1% of people are actually being held to account when you deal with wildlife crimes in South Africa. So that's really interesting. Then you've got your admission of guilt fines, right? So this is again, and this is all the information that's available through your department. So if you want to try and get this sort of information, it's very interesting to see and do those comparators. So you know, you've got your admission of guilt fines. So that, for example, and one of the biggest crimes here that were looked at was people picking up pieces of wood for fire in Mpumalanga. I'd say close to, I think about 60% of them, 60% of these crimes was actually that people just picking up wood for fire, but they were picking them up in a protected area, or they were picking wood that they shouldn't have that was maybe protected. So we know in South Africa, leadwood, for example, is a very important tree. It's very rare. It takes a very long time to grow, and so you're not allowed to touch or cut or do anything with that wood, and yet people get fined for that. So you can see the admission of guilt fines there is a lot higher. And then all the way at the bottom, you've got an S24G administrative fine, which is another type of fine. And so what's really interesting here is that you look at the amount of admission guilt fines paid. It's only 4.5 million rand. And then you look at the bottom, you look at administrative fines being paid, it's close to 74 million rand. And the reason why people would rather pay an administrative fine than versus an admission guilt fine is because one has a criminal element and the other one has a civil element. An administrative fine is a civil element. So people are more willing to pay because they won't have the stigma of a criminal charge or court order against them that would last, you know, for the next 20 years or whatever. So all of this information on the left is evidence, right? It's evidence that can be taken from the various reports in your country. And then what you do is you do your analysis, you get your access to information, you understand what that means. So percentage of convictions from the docket to convictions during the period of 2010 to 2019 has only been 5.7%. You know, percentage of convictions from prosecution to conviction during the period of 2010 to 2019 was 20%. Percentage of admission guilt fines paid, 91%. So it also gives you trends to show you what's actually working and not working. So on the left-hand side, you've got examples of fact, and on the right-hand side, you've got, on the left-hand side, you've got examples of evidence, and on the right-hand side of this PowerPoint slide, you've got examples of fact. It's the analogies that you brought up. So what type of evidence is there available for a journalist to actually obtain? Okay, so collection of real evidence, sorry about that. So for example, you've got the item itself, so rhino horn, a skin of an animal, the tool used to commit the crime, such as a firearm or a vehicle to transport the animal, a photo, a video, a sound clip, a recording with a witness, which is a sound clip. Those are all examples of real evidence, okay, that's needed in order for you to bring about the facts that you're going to bring out in your article. So how can a journalist collect, sorry, it shouldn't be read documents, it should be read real evidence? Well, is the information made available to the public? In other words, for example, has the Botswanian government released the photo of a particular poacher? You know, sometimes they hide the faces, sometimes they don't. In South Africa, there was a massive kingpin, I think it was about 2 years ago, that was arrested. And his face was all over the news, you know, and that's evidence that can be used to obviously identify the person, name him and shame him, etc., etc., etc. So if it's not been released by government, or let's say it's a minor, or let's say the charge hasn't been issued yet, what do? Well, you would have to follow your access to information laws in that country. Now, what's something that's really important here as a little tip, make friends with organizations like the LRC in your own country. So like, for example, in Colombia, you've got an organization called the Justia. They also deal with human rights and environmental and climate change and all of that. And they're a great organization to get hold of in Colombia if you can't get access to information from government or from a private person. So it's really great to work with civil society organizations, legal organizations that can assist you to get that information if you're struggling to actually get it from government. You know, it's it's in South Africa, we've got really good laws. And I think most countries have got really good laws. But the problem is, of course, government doesn't want to give that information. And it does become incredibly hard. I mean, there's countless of court cases internationally in Southern Africa where people have tried to get information and gone to court to get access to that information. And those are massive strategic litigation cases that need to be thought about and see if it's something that's actually worthwhile pursuing, because you're in there for the long haul. It could be up to 3, 4, sometimes even 7 years, in the case of South Africa. Witness and statements. So witnesses and statements from those witnesses, it can be used as evidence, right? It can be used as an information source, and certain protection for journalists of sources. This is really important here. So what do we do with whistleblowers? How are whistleblowers protected? How is that evidence protected? So a really good example, which I think, made international limelight, was the Gupta leaks, for example. How was that person protected? How was that evidence protected? How were the journalists looked at being protected? So, for example, in that particular, you've got the legal protections, but do they really work? It depends on the country. And so what journalists did in that particular scenario, which was really incredible, was that they actually had taken that information that was leaked to the journalist, and the journalist then actually made a very important connections with other people internationally, which then destroyed any ability for any person to try and target those persons, because if anything ever happened to the person who did the leak, or anything happened to the journalists who were writing about the Gupta leaks, that information were done between the various journalists in South Africa and other countries. So, there's a little bit of tactical play here when you're dealing with whistleblowers, when you're dealing with very sensitive information, when you get it. And there's another thing you also need to be incredibly aware of when you're dealing with obtaining information, is it even usable? Because sometimes there might be a national security angle to it. So, like, for example, if there's a construction that's going to happen on the White House, for example, right? That would be national security. Nobody should know about that. You receive that information. Are you going to be punished? Would you go to jail if you release that information as a journalist? So all of that kicks into gear when we deal with whistleblowers. But from a legal perspective, go and look at the laws in your country. So for Botswana, for example, you've got the Whistleblowing Act. Sorry. And while the press is not authorized to authorize reporting agency in terms of Section 8 of that Whistleblowing Act, journalists should not attract criminal and civil sanctions as expressed in the media practice. So there's a bit of to play here. So you've got the Whistleblowing Act, where journalists should not attract the criminal and civil sanctions as expressed in the Media Practitioners Act. So reporting of disclosures to unauthorized agencies can in fact incur criminal sanctions of a fine not exceeding 10,000 pula, or in terms of imprisonment of up to 5 years. So that's a very strict law. In Malawi, you've got Section 50 of the Access to Information Act that states that whistleblowers who disclose or attempt to disclose information within the public interest upon reasonable suspicion to a law enforcement agency or appropriate public entity shall not be penalized in relation to his or her employment, profession, voluntary work, contract, organization, etc., etc., etc. And that's similar to in South Africa. South Africa's Act, the National Environmental Management Act, actually says that you're allowed to whistleblow, and that you can actually protect that whistleblower if that information is in the interest of the public, to save lives, to prevent harm. Then you've got Mozambique. You've got the law on protection of victims and witnesses, was enacted to safeguard the interests of whistleblowers and victims who report corrupt schemes. Namibia, you've got the Whistle Protection Act. South Africa, you've got the Protect the Disclosure Act, and you've got the National Environmental Management Act. And unfortunately, in Zimbabwe, there's no standalone law that deals with protecting of whistleblowers. Okay, so moving on to the next one, collection of documentary evidence. Okay, so this is where a lot of the access to information processes would kick in when we're dealing with documentary evidence. So what do we mean by documentary evidence? Well, we mean minutes of meetings, maps, emails, letters, charge sheets, judgments, court orders, reports generated, SMSs, text messages, or anything essentially that's written down can be deemed as documentary evidence that can be accessed in one way or the other. Now, remember, there's always two ways of accessing it. It's either public information that's already been made available in terms of reports or statements or whatever it is. And then, of course, if it's not, you then have to go and fetch that information. And how you do it? Well, you do it through your various access to information laws in the country. So, for example, a documentary that's publicly accessible is the UNEP report on wildlife crimes, for example. And there was recently a new one that well, not recent, sorry, 2020. I'm still living in 2020, but that recently came up. So that's a report that's available, and they've got statistics in terms of what was the most poached, what was the most trafficked animals, which you saw earlier on in the slide at the beginning in the introductory part. Of course, if you need access to information through the laws, you need to check that. So, for example, in Malawi, you've got Access to Information Act 2017 in Malawi to try and get information of how many poachers were prosecuted in the last month, for example. They would then report that. Just a little side note, I know that there's the legal side and then there's the practical side. And the practical side is always the hardest part because government officials are always not willing to give that information. And this is where we need to think about advocacy strategy campaigns, get in touch with another legal NGO in that country, or maybe an NGO that works regionally, and see maybe this pressure can be put on there. You can also embarrass countries. Quite often the LRC makes statements to United Nations Human Rights Council about issues that South Africa has failed at. And then South Africa tends to feel very embarrassed when we make statements to the UNHCR, and they tend to try and make sure that they actually provide the information or they deal with the human rights violation that was highlighted in such statements. Here we've got collection of electronic evidence. So electronic evidence is similar to documentary evidence, for example, emails, but it goes a little bit further. It includes CDs, DVDs, electronic documents saved on a computer or on the cloud. And this is quite an important side because a lot of people get caught out like this. And it has worked in the past, but you obviously need to be quite savvy about it. But say, for example, somebody stores their information in the United States, or the cloud service that they have is in the United States. You then, or let's make it South Africa, because South Africa would then have to provide with the information. You then make an access to information PIA request to that company in South Africa for that information, and they are obliged to provide it as long as they don't violate their own data privacy laws in South Africa. But that information might have been information on the kingpins in France who've been trading certain type of furniture that has wood that was unlawfully or illicitly trafficked, for example. So it's very powerful and very important to figure out if you can. I mean, this is not an easy feat as well, but you can technically try and get information on the cloud from another country, even though that information might impact a company in another jurisdiction. So again, here, how can journalists collect electronic evidence? So let's just bring it back to the court. Like Lauren said, you've got Worldly, you've got Softly, you've got other payable subscriptions that have much bigger jurisdictions. So like, for example, you've got Westlaw, which includes America and Canada and most European countries. You've got Jutastat, you've got LexisNexis, and these are all legal electronic databases that collect information, collect court orders, that collect judgments, and where you can extrapolate information. Sometimes they're not the most up to date, of course, because there's a lot of backlog and backwork to putting a judgment onto those systems, but they generally are, I'd say 90% of the time, up to date. Okay, collection of scientific evidence. So here, scientific evidence is another type of evidence that is crucial when you want to prove a crime has taken place. So most criminals, including wildlife crimes, require experts and scientific evidence to prove a crime has taken place. So scientific evidence in terms of a journalist is critical in proving a claim of fact. For example, if you want to prove company X polluted a water resource, you need to get the water resource tested, and if it's being and to see if it's being polluted by X company. The same would apply in terms of poaching. If you're doing investigative journalism, and obviously you need to remain safe and make sure you're safe at all times. But for example, if there's rhino horns that are being transported from Zimbabwe to Kenya through their various regulations, but yet it's rhino horns that were poached in South Africa, Most data in South Africa, you've got data about the rhino horns, about the rhinos themselves, sorry, and they have a massive data system where you can actually pick up which rhino was poached. And so if you're able to get a sample of a rhino horn in Zimbabwe and then send it to the South African lab to find out if the rhino was in fact poached in South Africa, it might lead to, you might be able to have this trail of how in fact rhino horns are leaving the country in South Africa. So, types of scientific data, you've got air quality, soil quality, plant or animal damage, water quality. It's actually endless. I mean, there's so many types of scientific evidence there. What's great about this side is that if you do get your hands on scientific data, of course you need to make sure that you deal with it, protect it, that it doesn't get harmed in any way. So, like for example, if you're going to collect a water sample, you need to make sure that it's in a bottle that's sealed and etc. And then the next thing you should do is you should actually visit or try and get in contact with scientific labs. So, like for example, in Zimbabwe, universities are a great place to get into contact with scientists who are able to process that scientific information for you.
Good day, everyone. My name is Zahid Laher. I was introduced as the candidate attorney that's currently working with Lucian and Lauren. I'll be presenting just specifically on the principles of data privacy and its processing and the responsibility of the media when reporting on matters that use individual sources. So I think that the best place to start is to say that the WildEye platform currently, the way it was framed to us, is that it sits in the intersection between the role of the media in reporting on a matter of public interest and the rights of individual data privacy. So when it comes to data privacy, the principles of, there's 8 universal principles of data privacy, which comes through in the different jurisdictions' legislation. These principles are lawfulness, fairness, transparency, the requirement of using data for the purpose for which it was gathered, data minimization, only gathering data which is needed, storage of data, and accuracy of data. And what these two these principles mean is, or what they practically is, that they give data subjects or clients rights, and they impose obligations on processors of data. So the next 4 bullet points speaks to, these are just general standards of media ethics and media, what is expected of the media when they conduct themselves. And those are to maintain the highest professional and ethical standards. They must educate the nation professionally and responsibly. I thought those were 2 very important qualifications. Reasonable steps to ensure that that the information that they are giving out is accurate and balanced, and they must never publish false or incorrect information. So between between privacy law and the media's role, or important role in any state, this is it's in between that scope that the WildEye will be operating. Right. So with respect to the general law on personal data and privacy, the United Nations Developmental Group, always the United Nations is usually the place to start when it comes to global human rights issues. They have issued a guidance note on the regulation of big data. Right. So the definition that they've given to personal data is, it's quite a long definition, as you can see. I've highlighted the main parts to it, but it's information that identifies an individual, and it's personally identified information, and it is over this information that the right to privacy would exist. So there is no, you will see in the second part of the slide, there is no real accepted definition of privacy, but it leans to the thought of autonomous development, interaction, liberty, and free from interference or undue interference on the personal life. So now, what you'll see in South Africa, or what the rest of this presentation will do, is we'll go through the different legislative frameworks of privacy and data protection in each of the different countries. But I'll focus now first on South Africa and show you how the privacy laws penetrate into the journalistic space. So the overarching legislation in South Africa is the POPIA, Protection of Personal Information Act. It's quite an extensive piece of national legislation. It recently came into force. It had a staggered implementation. And what this does, it provides, amongst other things, rights to data processors. So wildlife, it provides rights to data users, and it puts obligations on data processors. So that would be, for example, your wildlife platform, and it sets out how data processors are to comply with the lawful conditions of processing personal data. While it does many things, it emphasizes the need for full and informed consent of a data subject before the data may be processed. However, what we want to point out is that the wildlife platform does serve to gather data for reporting purposes and reporting on matters that are in the public interest, which under Section 7, it allows for journalists to deviate from the ordinary POPIA obligations. So in essence, why it does that, it recognizes the role of journalists and artists and writers in any society, and subject to the limitations of an acceptable code of conduct, though that code of conduct can override the provisions and the obligations as found in POPIA, which I'll show you in the next slide, is a bit less onerous than the obligations that we put on corporate entities. So just to backtrack a bit, I'm sure everyone knows what personal information is. This is the definition that was given in POPIA. It largely mirrors the UN definition, only gives a lot more detail and breaks it down a bit more, so it's good to familiarize yourself, but the overarching principle is that it's identifiable information, and it's an extended definition of identifiable information. So yeah, so in South Africa, when it comes to data privacy and in respect of journalists, the Code of Conduct and Ethics for South African print and online media applies. This was published by the Press Ombudsman, and I would say it'd be important for the journalists your data wranglers to familiarize themselves with these two codes, and these two codes will appear throughout the different jurisdictions, different codes of conduct. So just to give you, it's all there for you to see, but just to give you a overview, Code 3 is for privacy, dignity, and reputation. Code 4 is the protection of personal information. What these codes do largely is that they mirror the provisions of POPIA in respect of a data subject privacy and importance of that privacy, especially when that person is a private citizen. And Code 4, while it's titled protection of personal information, but what this does is it sets out the general principles that appear in POPIA, but they're not holding journalists to the stringent measures of reporting and the others. So that would be, so these two would be your, I guess, the central piece of how you comply with processing and data legislation in South Africa. I just want to point out 3 other codes which will be important to note. One is Code 1.3 in South Africa, which requires the media to obtain news legally, honestly, and fairly, unless public interest dictates otherwise. This field of or this issue of public interest does allow for flexibility in other jurisdictions as well, which I'll get to shortly. And then Code 8, which emphasizes that the best needs of the children are paramount importance, and perhaps can be seen if that overrides public interest in what instances. And then the Code 11 specifically requires the media to protect confidential and anonymous sources, which is another theme that will come up in the different territories that we've looked at. So so I thought the best way to present this information of the legal frameworks in each of the different jurisdictions be by way of a table. What I'll do is I'll take you just summarily over the table. If you guys got any deeper questions, I'm happy to come back and discuss those. But in essence, where the law starts in any country is like, you've got the international law, which is not really binding, but the real binding source is the constitution. And you'll see if all countries have the right, well, almost all have a right to privacy. And if they don't have a right to privacy, they've got the right to individual rights and freedoms. So the countries that we've been asked to consider is South Africa, which is in the far left, Namibia, Botswana, Malawi, Zimbabwe, and Mozambique. So I think, I just as a general note, Botswana's regime is similar to data protection regime is similar to that of South Africa. It's got its constitution, it's got its act, which is about to come in force, and its act contains quite a lot of stringent data obligations. If we look at Malawi, Malawi is on it currently has the Electronic Transaction and Cybersecurity Act, but which does contain quite a few sections on data processing and private data, but there is specific legislation which is being drafted at the moment that's coming through. If you look at Zimbabwe, they have the Access to Information and Protection Act, and Protection of Privacy Act, but this only regulates the collection and processing of personal data by public bodies. Currently, they've got the Freedom of Information Act, which is coming through, as well as the Cybersecurity and Data Protection Bill, which similar to the South African regime and the Botswana regime, looks a lot more coherent, a substantive piece of legislation. Just as on a few other points, I mean, you'll see that in South Africa, there's an information regulator. In Botswana, there's a data protection commission. Malawi has a communications regulatory authority, and Zimbabwe has the postal and telecommunications regulatory authority. So those are all the bodies which look to uphold all of these rights to privacy when it comes to data in the different countries. Just a side note, Namibia and Mozambique don't have any at the moment. Namibia is in the most of drafting that, so that drafting legislation, which should happen soon. Mozambique is far off the cuff and actually has quite a lot of difficulties when it comes to the space. So this part of the table, item 2 just outlines that there may be other legislations which may need to be considered in the different jurisdictions when you guys are carrying out your work as part of the WildEye mandate. Namibia does have that data protection bill. In the meantime, Malawi's got also another data protection bill, and both Zimbabwe and Malawi have Official Secrets Act, which prohibits the publication of matters of public that undermine public security, which is also another theme that does come through in the Media Code of Conduct. So if I move on to the green part of this table, number 3, as we said previously, we have the data processing legislation, but this moves on to the Media Code of Conduct, which interplays with that type of legislation in each of the countries. South Africa, yeah, we've got the Press Ombudsman, which has published their code, which I've taken you through. In Namibia, their code pretty much they have a code, and it's already been it's available online, and it largely mirrors the South African code. So if you familiarize yourself with one, you'll carry over. Botswana has a separate code, and the important provisions which I'll move on to next are those of gathering of information, national security, and protection of sources, as well as privacy and the public interest. Malawi have a very interesting provision known as the right to know provision, and which is code 3.11, as well as the right to privacy. Well, it's enshrined in code 4. And Zimbabwe also, its code has similar provisions to that of Botswana. Sorry, I forgot to mention Mozambique. Yeah, it's quite a difficult reporting climate there. Journalists do run risks of numerous things when they report there, especially northern Mozambique, and there is no code of conduct in that country. So it looks like while there may be no laws, there are other difficulties that need to be considered when you're looking at that. So I'll just very briefly go through the rest of the next few slides. The Code of Conduct Botswana again emphasizes that people's personal lives should be respected unless it's in the public interest to do so. National security must not be compromised. This may be an important consideration when you're looking at the players who are involved in the supply chain of the illegal wildlife activity. For example, with the rhino horn, perhaps government. If you have to ask the question is this like a state-sponsored act, or is this something that will cause national threat? If so, you'd have to consider how you're going to present the information and what those specific laws do. An important provision I'd want you to know about is that, like obviously we're investigating crimes. It's a bit difficult to get people to talk about these crimes, but when you're gathering information, you should usually use open methods. You should not deceive the person that you gain the information from. However, there is flexibility when it comes to investigating matters of public interest. So when it is a matter of public interest, well, the words they use is surreptitious methods. So I guess that's something that you'll have to use on your discretion and look into. But that's the ordinary position. Lastly, the sources must be protected should they request it. So yeah, thanks. The next one is the Malawi's right to know provision, which places restriction on journalists and their methods of investigation. Source confidentiality is a very important theme. Minors and victims of sexual crimes should not be identified. Avoid making prejudicial remarks and avoid gathering information dishonestly. And also, when you're reporting on court proceedings, it should be a fair, accurate report of those proceedings. And then lastly, Code 4 in the Malawi Code also emphasizes again the individual's right to life and privacy. So yeah, so Zimbabwe is the last one, is the last jurisdiction I just want to note about its code of conduct. It's got its own it's got its own separate code of conduct. Code 13 is privacy, and again, you must journalists and investigators must respect private life, but there is a justifiable infringement on that when the matter being reported on is of public interest. And it goes on to list at 13b all the different instances of, or some of the different instances of what is public interest. And Code 19 also gives a gathering of information restriction. The last one I just want to talk about is, it's the same things we already spoke about. Zimbabwe also has a national security provision. It also requires journalists to protect its sources, and it has legislated an Official Secrets Act, which protects the publication of any matters that would impact official secrets.